And to further unpack this story, we are joined by political analyst Tshepo Kgadima live in our Morning Prime studio in Midrand. Thank you so much for joining us here this morning.
Morning.
Morning. Firstly, what are your thoughts on Zuma's IMC recommendation for a judicial probe into banks' alleged collusion being under consideration here?
Yeah, we have to bear this in mind. And let me first say this. Yesterday could not have been an easy day at all for either the Minister of Finance, Mr. Gordan, or the CEOs of the various banks that took that decision to close it. Yesterday, the President dropped a bombshell. And if they haven't yet realized it or recognized that bombshell, in the next 48 hours, it will dawn on them that indeed a bombshell was dropped. And we also have to bear in mind that when the President appears in Parliament and giving testimony, which is the effect of it, is that he's doing so effectively under oath. Because when you are in Parliament, anything that you say there is tantamount to a testimony under oath. So we must read it in that context. So what the President said, I think, yesterday, and it is good that the various members of Parliament, and particularly UDM, General Bantu Holomisa, posed that particular question. Because it is important for us to know what is the highest office in the land thoughts on this matter. It is common cause that cabinet that is chaired by President Zuma established an interministerial committee to investigate and seek answers on the closure following the request for intervention by Oak Bay companies. So that interministerial committee of 3 was established duly by cabinet. The fact that Minister Gordan chose not to participate in that, and it is also common cause that he chose not to participate in the work of the interministerial committee. But what remains is this: that report that eventually was produced by that interministerial committee, it is a cabinet report, because that interministerial committee was established by cabinet, which is chaired by the President. So therefore, for the President now to say, indeed, the recommendation as contained in that report is what he is considering, that by far was the most important statement, because he gone on record to say, yes, in terms of the premature statements by Minister Zwane, I did take a reprimand action upon him, and he has since apologized, the matter is closed. But it did not negate the fact that there is a report with clear recommendations. Now, those recommendations, and as the President has correctly said so, under oath, that he's considering them, for me, that is the most serious thing. But it is important that we should really have closure on this matter, because on the face of it, when you consider everything that has been said, and more so when you look at what I regard as legally untenable and an absurd action by Minister Gordan to have approached the courts seeking a declarata that he not intervene. If anything, yesterday's testimony by the President, it cannot be a good day, and unfortunately it has completely destroyed his course of action in terms of seeking that declarata. And why am I saying that? I'm saying that on the basis that we've seen that that actual court action itself has not progressed to the extent that it has. Because the effect of that founding affidavit by Minister Gordan has got a direct accusation against the Financial Intelligence Center. Because in his affidavit, he said there are 72 suspicious transactions. But what is the process? The process is that under the Financial Intelligence Center Act, there are prescribed transactions that have to be referred to the Financial Intelligence Center by the banking institutions. But once they are referred there as suspicious, it is upon the Financial Intelligence Center, comprising of the various law enforcement agencies and government agencies and authorities, to then take appropriate action. Now, what is really very interesting here is that the Financial Intelligence Center, on all of the 72 transactions, they never took any action. So if those transactions were suspicious, as referred, allegedly, by the banking institutions to the Financial Intelligence Center, the mere fact that there was no action taken, there was no prosecution, there was no those transactions were not reversed or stopped, it then holds that there was nothing unlawful about those transactions. So how then do you go and have a minister who says, well, these transactions are suspicious, more so because the Financial Intelligence Center has not availed this information to any other party, and it will be interesting to see during the court action how it did. But what is important for us as a country, it is now the president to proceed in terms of ensuring that the government that he heads can really bring a closure and understanding on this matter. There are two cases that I would like to refer to. The one is the Standard Bank versus Bredenkamp matter, which was had in the Supreme Court of Appeal in Bloemfontein. When you study that judgment, and particularly paragraph 65 of that judgment, he has got the effect of calling upon the state to regulate the manner in which banks can close their accounts, because right now that is not regulated. That process is not regulated, and we now end up with what is an apparent abuse of that unregulated process in terms of closing of the bank account. And most recently, of course, we had the matter between Absa Bank as well as Mr. Fanatlongwane and 6 of his companies. And once again, even though the causes of action were similar but not the same, it tells us that we have to get to a point whereby there is further investigation, and I can't see it being done outside of a formal judicial commission of inquiry that we can know for sure, and more so to say, well, where do we go from here? Because what has been invoked to say there is a client and bank relationship and that the banks should be entitled to do so in terms of...
Let's talk about the banks. Sorry to stop you there. Let's talk about the banks. What options do they have for them now if this IMC recommendation for judicial probe is considered?
Well, if I was sitting in council with any of the CEOs of the banks, by the way, this would be the time, I think, to come forth and do right and remedy what they have done. Because there is absolutely no... They can't hold cause in the court of law or in a judicial commission inquiry setting on what brought them to closing the bank accounts, not just of Oak Bay, but of a number of other people, by the way, whose banks were closed on an arbitrary reasoning of being branded a politically exposed person. And we now have to go and look back, by the way, that National Treasury in 2013, under the current Minister Gordan, when he was minister in that administration, Minister of Finance, they published what they call guidelines that then seek to brand people as politically exposed persons. And when that, of course, then eventuated in the current contentious, draconian piece of legislation called the Financial Intelligence Center Amendment Bill. And when you look at the banks, it would appear that they prematurely implemented the provisions of the Financial Intelligence Center Amendment Bill before it was passed into law. And that can only spell trouble for the banking institutions because they acted unlawfully and they seem to have broken the law. Unfortunate thing is in this case that Minister Gordan has to come forth and hold course as to what advice, if any, or what instruction, if any, he might have conveyed to these banking institutions. The president said the most important thing, they acted willy-nilly and they seem to have acted in a collusive manner. And those are very serious statements that we should read from the president's testimony yesterday.
Mr. Kgadima, thank you so much for your professional insight there.